Hey guys, back doing another live session here, answering any questions people may have, just general questions about criminal defense. Uh, just like last time, I've got some questions that were emailed that I'll go through, and if anyone joins the live and has any questions, just let me know or put it in the comments, and I'll see it and I'll try to answer the questions as best I can. I've got a question here from Juan Mendoza, and it says, do criminal lawyers have payment plans? Well, Juan, the answer is most do. And obviously, it's going to depend on the complexity of the case, the amount that we're talking about, the length of time it would take to resolve the case. But yes, most criminal lawyers have payment plans. We do here at my office. And I think most of the lawyers that I know also have payment plans. So that's a good question, and the answer is for the most part, yes. Do first-time felony offenders go to jail, asks John Toole. So John, that's a hard question to answer because it would depend upon what is the first offense. So if it's a first felony offense for, let's say, drugs, no, there's not a substantial likelihood of jail. There's probably a more likelihood of getting probation, deferred adjudication, something other than jail time. Of course, if it's a felony offense of murder, then there's a substantial likelihood of doing jail time. So there's not a real easy way to answer, do first-time felony offenders go to jail? And many times the answer is no. We can find some alternative, and also many times we can find a way to get a felony reduced. But that's about the best I can do on that one. Menda Arman asked me, what area of criminal law do you specialize in? And we have sort of a broad range. I have Thomas here in the office who specializes in DWIs. What does that mean? That means that he attends continuing education courses specifically in DWI, different sciences, the blood draw issues, breath test machines, and things like that. I have Jessica who, if she had to pick, she would say that drug cases, possession of controlled substance cases, are her favorite and what she likes the most. Myself, in my career, I've tried everything from prostitution to capital murder. So for me, it's broader. At different times and different fact patterns, there's just different cases that excite me and want me to get involved. I couldn't necessarily name one. For me, I've been doing it so long that it has more to do with the facts, the people involved. They're just different things that get me motivated. And I find something in every case I take on to use as my motivation to go through all the way to the end of the case. Javier Flores asked, how long can you stay in jail for assault? If we're talking about misdemeanor assault, it's a Class A misdemeanor, and the maximum penalty is up to a year in the county jail and a $4,000 fine. Now, that being said, again, we have lots and lots of people that don't go to jail for assault. There's a wide range of options depending upon the circumstances of the case, but there's always probation, deferred adjudication. Sometimes we get time served with a fine. There's lots of options other than going to jail. But assuming someone went to jail on a Class A misdemeanor, went to a jury trial on a Class A misdemeanor assault, and the jury found him guilty and then assessed punishment, it could be up to a year, though it's very rare for someone to get a year on a simple misdemeanor assault. Michael Parker asked me, what is the difference between a felony, misdemeanor, and infraction? So I kind of went over this last week. It's range of punishment. So the felony, it means TDC time, which is prison. Misdemeanor carries with it county jail time, and then an infraction, which I guess you meant to say like a Class C, like a ticket. There is no jail time. It's a money offense punishable by up to $500 fines. And of course, over all of them, the possibility of probation exists. But generally speaking, the difference between a felony misdemeanor and a Class C is just going to be the range of punishment that's involved. Obviously, there are some charges. The simplest one I can think of is possession of cocaine. There is no such thing as a misdemeanor possession of cocaine. So sometimes the difference can be the offense charged itself is either a felony or a misdemeanor. Jennifer Hughes asked a really good question that we get somewhat often, and that is illegal possession of a firearm a federal crime, and then what makes a charge federal? Jennifer, if you had been a little bit more specific about what you mean by as illegal possession of a firearm a federal crime, it would be easier. For instance, if the illegal possession is because of a prior felony, yes, that can be a federal charge. What makes the charge federal is because the felon, the person with the prior felony, is a prohibited person, right? And then what gets it federal is that the gun would not have been manufactured in Texas. And so the gun traveled in interstate commerce, which gives the feds jurisdiction to charge a case. Now, does that mean that the federal government always charges felon in possession of a weapon? No. A lot of times they don't, and there's no real rationale as to why they do, when they do, or what have you. But yes, it can be, and oftentimes is, and here in Galveston County recently, they've had an uptick in federal charges being filed on felon in possession of a weapon. I hope that answers your question, Jennifer. If not, let me know. Here's another question we get a lot, and I guess it's just for lack of knowledge, but it's what is the difference between probation and parole? So probation is a sentence that you get in lieu of incarceration. So instead of going to prison, you're placed on probation for a term of years. And if you violate that probation, then you can be sent to prison for a term of years. Now, parole is different in that parole means you have been to prison, you've been let out early, and you're serving the remainder of that sentence on parole. So they're different in that one is to avoid prison. One means you got out of prison early. That's parole. Essentially, the reporting requirements and all that are the same. You have to report once a month to an officer. You're subject to random drug testing, that kind of stuff. One big difference is if you violate your parole, there's a limit to what number of years you could go back to prison, because there's a limit to how many years your original sentence was. If you're on deferred adjudication, which is a type of probation, that means at the end you do not end up with a felony conviction, the entire range of punishment for that offense would be open. Meaning, if you had a first-degree felony, which is punishment range of 5 to 99 or life, and a fine not to exceed $10,000, and you take a deferred, let's say you take 10 years deferred adjudication, and then at some point during the 10 years, it doesn't matter if it's the first year or the last year, you violate it, at a hearing, a judge can sentence you from anywhere from the original range of punishment, 5 years to 99 years or life. And I've seen it happen. I had a case where I put a young man on deferred adjudication for a first-degree felony. A couple of years into it, he had some problems, and they hired a lawyer no one locally had heard of, and that lawyer came in and conducted his hearing, and that young man did get life at the violation hearing, and that was unfortunate. But generally, that's the Oh, okay. Now, the opposite of deferred, straight probation, which means you are convicted, but you still get to avoid jail time, has a term attached to it. So, for instance, it might be 5 years in TDC, probated for 5 years. So that means that if you violate, you're capped at 5 years. You can't get more than 5. So on a straight probation, you generally know what your maximum could be if you violate. On a deferred, you would not. So I hope that helps clear up what the difference between probation and parole is. Next, somebody asked me, what is restitution in the criminal law context? So restitution in the criminal law context generally means that you're paying money for some damage caused. Let me think of an easy example. Let's say you break into someone's car or house, and you obviously, if it's a car, you're going to break a window to get in. And if it's a house, maybe you kicked in the door. I mean, who knows? Anyway, in the commission of the crime that you're charged with, it's alleged that you caused monetary damage to someone. So sometimes, as a result of plea bargain efforts, restitution becomes an issue. Like, if we pay restitution and pay it up front, can we get, whatever punishment I'm trying to negotiate? Sometimes, like on a bigger theft case, maybe someone's stolen from their employer over a term of years, and the dollar amount is much larger, more than someone would be able to pay up front, then it becomes a part of probation or deferred adjudication that you have to pay X amount of dollars in restitution over the course of the term of probation that you get. And before I move on from that, we talk about probation, community supervision, deferred adjudication. They're sort of all used interchangeably. In reality, it's all community supervision, but then there are distinctions. Probation means that it was a straight conviction. And then there's deferred adjudication, which is still under the umbrella of community supervision, but it means that you are not convicted. And if you successfully complete that deferred, then the case would be dismissed and you would never become convicted of the offense. But generally speaking, they're all under the umbrella of community supervision and corrections. Out here in the real world, everyone just calls it probation. Even if it's deferred, a lot of times people just say probation, but that's just because it's used so frequently. But there actually are subtle distinctions. But yeah, back to restitution. So restitution means that you're paying some money for some harm that was done that's alleged in whatever you've been charged with. Okay, can the judge send me to jail even if I get probation? The answer is technically yes. Judges maintain, depending upon whether it's a felony or a misdemeanor, they do have a number of days that they can sentence you to as a condition of probation. Now, it very rarely happens without knowledge, because if it's a negotiated case, then I've negotiated a plea bargain and we have some idea of whether or not the court is going to take it. And so sitting here 23 years practicing, I can't remember. I really don't remember an instance where I had gotten probation and then all of a sudden out of nowhere the judge incarcerated my client as a surprise. I can't think of it. Now, what does happen frequently is if we go to a jury trial and the jury gives us a probated sentence, sometimes the judge will add days in jail as a condition of that probation, and that has happened, and that's generally some sort of a signal that the judge thought the jury was too lenient in their probated sentence, and so he wants to put a little sting, he or she wants to put a little sting on it and give you some jail time to go with it. That happens. It's not regular, but it does happen. So I guess technically speaking, yes, the judge can send you to jail even if you get probation. And hey, Patricia, I see you on there. I don't see anyone asking any questions. So I guess we're kind of going to go ahead and cut today shorter. I did want to tell you, and I forgot to say it last week, on these general criminal defense questions, Jessica and I have published a book on, the title is I'm Charged with a Crime in Texas, Now What? And it's sort of just general information for people who've never been involved in the criminal justice system and want to know. On my website, you can get a free download of the e-edition at texascriminaljustice.com is my website. And you can download Jessica and I's book. It's free. If for some reason you're just dying to have a hard copy, you can buy it on Amazon, and you'll get a pretty, bound book. But if you want the free e-edition, it is on the website. And so anyone who just wants general information, go to the website. You can get it for free. Thomas and I are in the final stages of publishing sort of the same thing, but only in regards to DWI. So at some point in the future, I'll have Thomas on here do a live and take your DWI questions. But thanks, y'all, and hopefully I'll see y'all next week.